If you or anyone you know has been denied long-term disability benefits, please reach out to us on the World Wide Web at buchanandisability.com. We help with long-term disability. We help with private disability insurance. We help with long-term care claims. We help with large health insurance claims. We help with life insurance claims. We can help whether those policies fall under the federal law of ERISA, the Employee Retirement Income Security Act of 1974, or whether those policies are individual policies purchased directly from an insurance company. ERISA applies if you get the policy from an employer in most cases. So if you have any questions about that, reach out to us on the World Wide Web at buchanandisability.com. We help people all over the United States. We're not licensed in every state. We are licensed in just a few states. And once again, you can see what states we're licensed in on buchanandisability.com. But we help people all over the United States, working with local attorneys and also following the local rules where we need to in states where we're not licensed. Because we have such a niche practice, we reach out all over the United States and people reach out to us. So we're happy to help. Once again, buchanandisability.com. So in today's topic, we're going to talk about 3 mistakes that people make when they try to handle a long-term disability case on their own, especially if the policy is subject to ERISA. What's the most important thing someone needs to know about a long-term disability policy? If they get it through work, it's almost always going to be subject to a federal law called ERISA, the Employee Retirement Income Security Act of 1974, a law that was passed in order to protect employee benefits, but it's been interpreted in many ways that help insurance companies and employers. And today, again, we're going to talk about 3 big mistakes people make when they have an ERISA policy. They don't understand how the system works. Or if you have a policy through work, unless you work for the government, then your policy probably falls under ERISA. Some churches are exempt, some are not. If you get your policy through a union, it still falls under ERISA, even if you work for a church or the government. So ERISA applies in a lot of cases. What's the least you need to know about an ERISA case? You don't make one of these top 3 mistakes. Well, one of the biggest mistakes that people make is thinking that they can appeal to an insurance company, that the insurance company is going to fairly consider whatever they appeal. And if the insurance company denies the claim, then they can go hire a lawyer to take that case to court. And a lawyer can get in better evidence when they go to court. Huge mistake. Big mistake. Mistake number 1, most people make in ERISA cases is not understanding that they are not allowed to submit more evidence when the case gets to court. The legal system that works in ERISA cases essentially calls this a closed record. That the way federal courts decide ERISA cases is they look only at the evidence that the insurance company has obtained and that was submitted to the insurance company. Basically, the rule is often stated as any information that the insurance company considered or that was presented to the insurance company. So during the appeal process, when you first file a claim with a long-term disability company, if they deny your claim, they're supposed to give you 180 days under ERISA to appeal. And after you do that one appeal, the insurance company has a certain amount of time to make a decision. And then normally that's the final decision. Some policies offer an optional additional appeal. Very few even require one more appeal. But the point is, when you go through that appeals process with the insurance company, that is your only chance to submit more evidence to the insurance company that shows why you're disabled or why you qualify for benefits under the policy. If you submit evidence to the insurance company, then it will be in the record, it will be considered. If people working on their own try to say, oh, I'll just tell the insurance company I'm disabled, or they hire a lawyer who doesn't understand how ERISA works, and the lawyer just sends in a mean letter, and the lawyer says, well, we'll get more evidence in, we'll hire some doctors to talk about how disabled you are when this case gets to court. Huge mistake. Because when the federal court gets the case, when lawyers like us end up taking on one of these cases and filing in federal court, the only thing the federal court can look at as far as proof of disability or proof that you qualify under an ERISA policy is the evidence in the file, which means the documents the insurance company had, the documents that were submitted to the insurance company. You've got to understand that has to be submitted before the insurance company makes their final denial, before they make their decision on these appeals to the insurance company. So that's mistake number 1. Mistake number 2 is that people have disability policies and they understand they need to submit something to the insurance company, and they simply submit a letter from their doctor saying they're disabled, or they submit a letter from their doctor saying they can't work, or they just submit just the medical records without even getting the letter from their doctor. That is another huge mistake people make when they don't hire an attorney. So what are we talking about that they should submit? Well, they need to submit something that shows why they can't work. And by that, I usually mean restrictions and limitations. Well, what does that mean? Well, if you have a bad back, then maybe you can't lift a heavy weight anymore. Well, let's get the doctor to say something specific, like that you can't lift over 10 pounds, or that you can't stand up for more than 2 hours during the workday, or that you have to lie down during the workday. What if you have cancer or some other illness, that you have so much fatigue that you have to rest during the middle of the day, that you have to lie down in bed or in a recliner for at least half of the workday? Those are restrictions and limitations that would affect somebody's ability to work. If you look in the policy, it'll usually say in a lot of ERISA policies that you have to be disabled from your own occupation for the first 2 years, and then after that, it's any occupation. Well, having the doctor say this person can't do their old job anymore, that's a little bit helpful. But why can't they do their old job anymore? Because they have to lie down during the day, because they have to elevate their legs, because they have so much pain they can't concentrate. Okay, then after 2 years, why can't they do some easier job? Why can't they do any job in the economy, or at least a job that qualifies under the policy? We as attorneys help people on a regular basis by getting their doctors to fill out forms that define the restrictions and limitations. And that also, we sometimes reach out to the doctors when they're able to do a sworn statement. We have the doctor walk through the person's medical history, the findings, and why those cause restrictions and limitations. In some cases, we might also get testing like a functional capacity exam. We also will get other opinions, if we can, about the person's restrictions and limitations, so that we will show that they have limitations, that the reason why they qualify for disability is not just a doctor saying they're disabled, and certainly not just medical records, but in fact, it is the fact that they have that the person has restrictions and limitations, and you have a doctor willing to say that, or you have other testing showing restrictions and limitations. What are some of the restrictions and limitations that count? Very limited weightlifting, very limited time that a person can stand, the fact that a person can't sit for very long. More in better cases, we have the doctor saying the person has to lie down during the day, or the person has pain so bad that they can't concentrate, that they have too much fatigue to attend to any work tasks for any length of time or meaningful length of time. Those are all extremely important. One other sub mistake here that's often comes up in these type of cases is thinking, well, my doctor filled out the form the insurance company sent that said I had restrictions and limitations. Don't rely on that. That's another huge mistake. This is sort of part of the same mistake, not getting your doctor to adequately describe your restrictions and limitations, because the form the insurance company uses is a trick form in many cases. It doesn't go into enough detail about why you can't work. It doesn't actually have a checkbox that would include work in many cases. Basically, it's not exactly what it says, but it might as well say this: check box 1 if your patient can work full-time with no restrictions. Check box 2 if they can work full-time with no restrictions with just a little bit of fatigue. Check box 3 if they can work full-time with no restrictions but maybe have some fatigue and need rest, but they can do it during the normal rest breaks. Check box 4 if they might need some rest but they can be reasonably maintained and they can still work. Well, which box says you can't work? Well, there's not one on the form. Sometimes they'll have 3 or 4 boxes that you can work, and the last box says, check this box if your patient can't do any work activity. Well, that would be disabling, but no doctor's going to check that unless a person's in a really bad condition, like they're paralyzed or stuck in bed all the time. Most normal people with disability cases fall somewhere in the middle where they still have significant restrictions and limitations. They can't work full time, and they certainly have to take a lot of rest or have pain that would interfere with a normal work schedule. The boxes on these forms don't ask those questions. Don't give the place for a doctor to reasonably fill that out. Maybe you get lucky, your doctor handwrites something in, but most of the time, the doctors just check the forms, and if it's one created by the insurance company, guess which way it's likely to come out, even if the doctor's trying to help you. So mistake number 2 is not getting the doctor to be specific enough about your restrictions and limitations, and a sub-mistake of that is if you do that, relying on the form from the insurance company. Don't make those mistakes. Mistake number 3 is not matching up the opinions of restrictions and limitations with the actual definition of disability in a way that shows that you can show a federal judge, that shows anybody who looks at the file that you're so disabled that you can't do any of the work that the policy says you need to be able to do in order to be denied benefits. What do we mean by that? Well, often these policies after 2 years say you have to be disabled from any occupation. Sometimes they say any gainful occupation, which means certain earnings requirements, like it has to at least be a job that pays something like 60% of what you made before or something like that. But some policies don't even have that. They just basically say you can do any occupation. You can take tickets to the movie theater if that's even still a job, or that you can be a security system monitor where you sit in the basement of a high-rise office building and just look at cameras and don't do anything, which is also sort of not really a real job, but insurance companies try to say those are real jobs. So how do you get around this part, or how do you successfully deal with this? Well, once you get a doctor's restrictions and limitations, you need to look at the definition of disability in the policy. And then often the best way to do it is to get the report from someone called a vocational expert. Often these people do a lot of work for the Social Security Administration, but they also do some work in court cases, appearing as expert witnesses. And their job is basically to say, if a person has these restrictions, limitations, what jobs can they still do? And a person with some restrictions, limitations, maybe the vocational expert can name some very easy sedentary jobs the person can still do. If we as attorneys have done our job right and you really are disabled, the insurance company will still try to deny the claim unless we have just overwhelming evidence. And sometimes that evidence is we get the doctors to describe in great detail what your restrictions and limitations are, and then we hire a vocational expert to do a report that says, look, somebody who has these restrictions and limitations, there's no way they can even do a simple sedentary job. There's no employer out there that allows people to lie down in bed for half of the workday. There's no employer out there that will hire somebody who cannot concentrate enough to attend to simple 1 and 2 step tasks when they're in a lot of pain. And if somebody who's in pain most of the time, there's no way they can do this job. Similarly, if they have too much fatigue, if the doctor says the person has too much fatigue to attend to a task, that they need to rest for large portions of the day, we often get what you need in the record is something like a vocational expert that says, with those restrictions and limitations, there are no jobs in the economy that somebody can do, or there's no jobs that meet the definition of disability. This is just a small part of the process of helping our clients win their disability cases, is obtaining the evidence that we get into the record under the first part of what we talked about today, that we get the restrictions and limitations documented so we can show the person's really disabled, and then we match it up with the definition of disability, getting vocational experts. And I see a lot of people who try to do this on their own mess up at least one of these things. Often all three of them are messed up by people who try to appeal on their own. So if you have any questions about a disability claim and you've been denied long-term disability, you can try to do this stuff on your own. And I've given you some big advice on how you might do that. And by the way, let me be clear about this. This is not legal advice that you can take home and say you relied on Eric Buchanan and then it's legal advice. If you come to us and you hire us, I can give you legal advice. The other attorneys can give legal advice. But today's podcast is just to explain these are common mistakes we see people make before they come to us. Don't try this on your own is my advice. If you want any advice from me today, if you have questions, contact a disability insurance attorney before trying to appeal your ERISA long-term disability case on your own. And you can reach out to us on the World Wide Web at buchanandisability.com if you'd like to learn more specifically about this and to see if we can help you with your case. But please, I wish I could give more legal advice over podcasts. I just can't really do that. The facts of each case are different. But what I can tell you is generally these are 3 mistakes that people often make before they come see us, and it makes it much harder for us to help them if these mistakes have already been made. The sooner you go talk to an attorney who understands how ERISA long-term disability cases are handled, the better off you'll be. Understanding how these steps work and understanding how the rules of the game are played is just such an important part of the process. So if you have any questions about any of that, please reach out to us on the World Wide Web at buchanandisability.com.